Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thank you for joining us as we go live today. We were a few minutes late. Why? Because had actual legal matters to take care of this morning on a Saturday, because that's always the best time for clients to come in, or it seems like it is for their schedule, so they don't miss work. But they always seem to go a little longer than expected. So the first thing I want to talk about today is what is going on with the Patrick Frazee case down in Teller County, Colorado. There was a motions hearing that was set for yesterday on Friday, and frankly, not that much was decided. And what's really frustrating to me is that all criminal court cases should be public record in the state of Colorado. But they put limitations on who can do this for no apparent reason. It's a public court file. Everyone should have access to all the pleadings in there. If there's something that needs to be redacted, then the court can suppress that online. But for some reason, they prohibit it, and they want you to go through some other public portal where they've approved that it's okay for the public to see, which I think is completely outrageous. It's public records. They need to be public, and yet they do this. And the Colorado courts got in trouble a while ago because it was determined that for some unknown reason, the courts were suppressing files so no one could have access to them. There has to be a darn good reason why public files of a public court proceeding can't be made accessible to everyone. It is absolutely frustrating. So we have most of the motions that were filed in this particular case, and we have proposed orders that were submitted by the prosecution because apparently somebody thinks that we can't handle the truth when it comes to the motions filed in the public record. So the judge heard a few matters of evidentiary hearings yesterday. One specifically was a motion to suppress that was filed by the defense in this particular case. The allegations basically allege that when the Department of Social Services, or Human Services as it's called here, went and spoke with Mr. Frazee and discussing the status of the child, that he made statements saying that he had been in contact with Kelsey Barrett when the police actually think that she was deceased. So obviously the government wants to use those statements to show basically consciousness of guilt and that he was lying to the Department of Human Services. Now, yes, there is a Fourth Amendment motion here because, remember, the first 10 Amendments Bill of Rights only applies if there's government conduct. Well, yes, clearly this woman is from the Department of Human Services, a government actor. However, for her to truly be a government actor in the sense where it's going to be a motion to suppress, she has to be able to, the defense has to be able to show that she was basically there on a mission from the police to extract these statements of what they would otherwise unable to be able to do so. So the judge took it under advisement. I'm assuming he's going to write a written opinion, but I think that motion will be denied. Now, the prosecution certainly wants those statements to come in because it's going to try to show consciousness of guilt. All right. Now, the other matter on the Patrick Frazee matter is, I think, of some significance, is that the prosecution requested that the defense endorse any alternate suspects in the case, okay? So what does that really mean? When someone is charged with a crime, the government has to prove certain things. They have to prove that it was the defendant that's charged, not somebody looked like him, not someone using his identity, wasn't somebody else that actually committed the crime, but it was him. So they have to prove identity. That's always the critical thing in any kind of case, whether it is a homicide case, an assault case, a criminal mischief case. They have to be able to show that it was the defendant that they charged. Now, we've talked about this previous when we've discussed the Frazee matter. I believe that and it's no secret, and the prosecution knows this, and they're ordering the defense to order that they're going to go after Nurse Lee, okay? And for those of you who aren't familiar or need refreshing as it relates to Nurse Lee was the, I guess, girlfriend of Mr. Frazee, who he allegedly asked her on 3 occasions to do away with Miss Barrett, and she was going to go do it on 3 occasions but chickened out. But then she alleges that Patrick Frazee killed Miss Barrett, and then she drove from Idaho and helped him dispose of her body, etc. So that's it in a nutshell. I'm sure I offended somebody in that quick description of it, but that's a quick description of it. So the defense, if I was the defense, it's not any secret that the defense is going to argue that Nurse Lee is the one who actually killed Kelsey Barrett, assuming they concede that she is in fact dead. Now, there is no body that has been discovered. The DNA testing that was supposed to be done regarding a tooth that was found on the property, we don't know the results of that yet. So assuming that there is no conclusion as to DNA, I'm sure the defense will say she's not even dead, but if she is, Ms. Barrett is the one, or not Ms. Barrett, Nurse Lee is the one that killed Ms. Barrett. So that's it. So as the defendant, you can sit there and say general denial, okay? I didn't do it. You can also assert affirmative defenses if you are charged in a homicide case of, I did it, but I was legally justified in doing so because they attacked me. They did something that put me in fear of death or serious bodily injury, and so I had to do that. I don't anticipate that would be a defense, but you never know because they know things that we don't know. But the defendant can't get up and just simply say, so-and-so killed the victim in the case. So for an alternate suspect to be able to actually present evidence that you think someone else has done this, the court basically has to give you permission to do so. And you have to show that somebody was actually there, that somebody was actually had the opportunity, and it's likely that the other person did it. I had this situation years ago in a, it was basically a burglary robbery case. My client was accused of robbing a bunch of people, houses, and then ultimately somebody was shot. Well, we tried to look to see who the other burglars were with the same methods used, et cetera, to try and show that was the real burglar, not our client. The court did not allow us that because there wasn't enough of a nexus. Now here, I think it's going to be pretty darn clear that they can say that there's a nexus between Nurse Lee and the facts of this particular case where they have a legitimate alternate suspect case. The prosecution knows that. They want to be able to be prepared to defend against that, although it shouldn't be any secret. That's going to be, probably one of the first questions that the jury will give to Ms. Barrett is, how do we not know that you are the one that, were responsible for the disappearance and or potential death of Kelsey Barrett? So that is the issue for Patrick Frazee. He has a pretrial conference next month. The court will have made those rulings. Hopefully they have all the DNA results and that this trial will go, which is actually pretty quick as it in terms of a homicide trial. It's been on a pretty fast track. So that'll be interesting to see how that will happen here. Hold on one second. Yeah, I was just looking at a entry of appearance here regarding the special appearance for Crystal Kenny, who this is in the conservatorship action. And it's interesting that the attorneys for Miss Kenny, Miss Lee, Crystal Lee Kenny, she was brought in as it relates to the conservator action, and they moved to dismiss that matter. And coincidentally, the law firm of the attorney for Miss Crystal Lee Kenny, her husband is handling the matter for her as well. So, not surprising. It makes sense if you're going to have an attorney handle it. You will have the your husband's firm handle the related matter where there could be a potential conflict. So that's interesting matter there as well. Also, as it relates to, grab my pile of stuff here, there's also the wrongful death suit that was filed by Miss Barris' parents in United States District Court. And as you can see, good old stack of paperwork, and yet really nothing has happened. But in the federal courts, everything is done on paper. They really don't like to do it. But the last real motion of significance was that there was motions to dismiss, as well as the motion to stay the discovery pending the outcome of the criminal case. And in this particular matter, the United States District Court did in fact stay discovery pending the criminal matter of the defendant, because obviously Mr. Frazee would have Fifth Amendment protections as far as having to give a deposition or anything along those lines, but he also has an absolute right to have the discovery made available to him. And frankly, even the prosecution couldn't get the discovery, not the prosecution, the plaintiffs in the wrongful death case would have difficulty getting the information in the wrongful death case at this point, and frankly, it would be a distraction. I'm sure the prosecutors would not want that to take place, because then all of their investigators are then going to be subpoenaed for a for the civil proceeding, where they would be subpoenaed for depositions, having to turn over their files, and it would be a huge, huge mess. So in that particular case, United States District Court judge, the chief judge, Judge Brimmer, stayed all of those discovery proceedings until the criminal case is done, which is not surprising, which is not unusual at all. That's normally the way it's done. That happens in the Watts case as well. And actually, let me hold on, because I think I have my Watts pile here as well, but it's out of reach. I'll grab it. Okay. It's been a busy week, and this was on the Watts matter. I asked my assistant to look up and obtain all the information as it relates to the wrongful death action as well. And it looks as though there is a status conference set for November 22nd, 2019 at 9 a.m. for a status conference in this particular case. And they want to set the court had issued an order as of August 1st in the Watts civil case, where the plaintiffs seek an entry of a default judgment against the defendant, Christopher Watts, in the amount of $6 million for the wrongful death and survival action. And it says, because the amount of damages sought are not liquidated or in an amount calculable through a mathematical process, and cites the case law for that authority, the court must hold a hearing to determine the proper amount of damages pursuant to Colorado Rules of Civil Procedure 55B and Colorado Revised Statute 1363-101. So, what does that really mean? The Ruzick family filed a motion for a default judgment because Chris Watts did not respond to any of the pleadings in that particular case, and frankly, why would he? They have no chance of ever getting any real monies from him. They can garnish his account that he'll have at the Department of Corrections. But even if he ever gets to work, he'll probably make about 22 cents a day. So this is more of a symbolic nature. And if Watts were ever to write a book, receive any sort of proceeds, this would make sure that he would not be able to get the any of those monies to make his life more comfortable. And but it's really somewhat symbolic. But they ask for, in their prayer for relief, in their motion for a default judgment, and it basically alleges that they request a judgment in the amount against Christopher Lee Watts in the principal amount of $3 million, exemplary damages, $3 million, and costs of $521.54 for a total judgment of $6,521.54 plus pre-judgment, post-judgment interest at 8% annum, and any other relief that the court deems appropriate. Now, when they have a hearing as it relates to damages on this default hearing, they can basically say pretty much whatever they want, but they're asking for the $6 million. The judge will probably impose that, but he has to, in fact, have a hearing on it to determine the amount of damages. And that status conference is really for the hearing in the court to determine how long the hearing will they set it for a hearing, but it will not take long. And obviously, Christopher Watts is not going to participate in that in any way. And then, as it relates to the house, we talked about the issues relating to the house and the sale of the house the other day. And I'm looking through the documents here from the public trustee's office, and it doesn't look like there's any real new date set. There's been some talk that maybe the bank was going to try and donate the house, and that it would be done in some sort of park or something along those lines. But the city and the homeowners association, it would seem unlikely that anything along those lines would in fact take place at all. So that's where that is. Kind of a long introduction, but it has been a busy week, and I apologize for not being able to basically put out more videos this week, just because it has in fact been busy. And the week before that, I think we were in court, and the week before that we were traveling. So I do apologize and try to get this a little more scheduled. Yesterday, I was hoping to be able to do a video and get that out, but I was testifying as an expert witness in a case, and I wound up spending all day there because they called me last. So let's take a look at the comments and see what people want to talk about today. If you have a question, please type it in, and we will try to answer that question. Let me go just to the very end here, and we'll see. What? People are saying they can't hear anything? Some people are saying the sound is good. One person says can't hear anything. I'm sorry, but I think we can hear. I haven't. Usually, if we have a sound issue, we get lots and lots of people complaining that there's sound. So hopefully the sound is, in fact, fine. All right, so let's talk about anything else. And obviously, we have the Jeffrey Weinstein matter is still... Jeffrey Epstein, Harvey Weinstein. The Jeffrey Epstein matter, where people are still talking about, why was he let alone? Why was he not being supervised? The coroners ruled that it was in fact a suicide. So, we'll see. My biggest gripe about that is that no one's ever fired. I think the warden was transferred out, not fired. The correctional people, no one's been fired. They've been put on administrative leave. How long does it take to do one of these investigations? Seriously, at the most, we're talking a couple of days. Now we're at least about 2 weeks in. Really? Come on. I just don't get why everything takes so long in the federal government to actually ever get done and investigated. And hell, by the time they ever get done, maybe it's because they have, usually at least a 5-year statute of limitations on something, and they just figure there's no rush. But usually, it's a criminal matter. Time is of the essence. Let's get it done. Because not only is it fair to the United States and the government to bring a case, but if you're a defendant, you want to be able to have access to your witnesses, videos that have been are out there that maybe haven't been preserved or anything along those lines. So it's like, just get to it, guys. It just drive me one. I had a case once that sat on a U.S. attorney's desk for literally 3 years, and as the statute of limitation was coming up in the state case, they finally kicked it back. But in the meantime, all the witnesses that would have been relevant were gone. We couldn't find it. It was regarding basically people that were transient, and you just simply it's just frustrating as hell. I don't understand why any of these investigations take so long. It's it's not like they have a shortage of people doing it. So here it says, Tina Silver, the autopsy said he was murdered. No, the autopsy came back that he was, in fact, it was a suicide. But he had a couple of broken bones in his neck, which is a little unusual, particularly the hyoid bone. But, we'll see. Either way, Mr. Epstein was probably going to have a difficult time, wherever he went, in fact, if he made it to trial. So, and this may be getting a little bit into the weeds here a little bit, but jumping back to the Frazee matter, okay, is that there is a thing in the law called 404B evidence, okay? And there's a fundamental principle in our legal system that a defendant has a right to be charged on the charges before him and nothing else. If he was a bad guy or had done similar things in the past, then he, those shouldn't be brought in where somebody can say, oh, you were a bad person in the past, therefore you are probably a bad person here today. It's called propensity evidence, okay? If, you as a defendant were charged with something and you'd say, hey, I want to be charged in this count and this count alone. But more and more frequently, the district attorneys, United States attorneys, not so much, they bring in what they call 404B evidence. And under the rules of evidence, 404A says you can't bring in any bad character evidence. 404B says you can bring in bad character evidence of modus operandi, absence of mistake, those type of things to show, it wasn't just an accident, that you actually did something. And the prosecution has to, show, hey, this is why we're bringing it in. It's not just propensity evidence, but it's simply that we want to show that this is what he does. This is his pattern. This is how he does things. You see it lots in domestic violence cases. He's, he always chokes the girlfriend or the wife. This is the way he does it. It's happened before, so he can't say it was self-defense or it wasn't an accident. They do it more and more these days. The defense in the Frazee matter wants any 404B evidence. It's unclear from the order, but it doesn't appear that there is, in fact, any 404B evidence. And the thing that's frustrating about 404B evidence is if you went to trial and you were found not guilty, but yet the case comes back up you're charged in yet another case, even if you were found not guilty, the prosecution can still bring that information in. And it is, it's rather frustrating from a defense standpoint. And frankly, as a prosecutor, I wouldn't bring in 404B evidence unless I had nothing else. I think it shows a weak case on the part of the prosecution because they don't want to just focus on the facts. They got to bring in all this other stuff to try and do that. Angel 1973, can the DA convict without a body? That's referring to the Patrick Frazee matter. It is going to be, in my opinion, difficult. I don't think the defense should actually concede that she is, in fact, deceased. All right? We've seen this also in the Doulos matter in Connecticut, where everybody thinks, not everybody, a lot of people believe that Jennifer Doulos is deceased. She's gone. No one has seen her in, almost 3 months now. And here we are, and no one's been charged. The husband and then the girlfriend in that particular case have been charged basically with tampering or kind of an obstruction of an investigation. But no murder charges have been brought. Why? There's no body, okay? So is it possible to convict on a case with no body? Yes. Is it a heck of a lot more difficult to convict without a body? Yes, it is. The prosecutors in the Frazee case are going to have a difficult time. One, there's no body, and two, you have somebody that basically has admitted to participating in the alleged disposal and cleanup, but she had a lot of motive for Ms. Barrett to go away. She wanted to be the new girlfriend. Apparently, according to her, she had been asked on multiple occasions to do this, and that she actually was going to do it on 3 occasions, but to use her words, she chickened out on the case. So I think it's going to be, I wouldn't say impossible, but it's definitely going to be much more difficult. And there's a huge alternate suspect that's going to be sitting in there. Nurse Lee Kenny's going to be sitting there, and it's going to be, she's got a lot of explaining to do, okay? And she got such a smoking deal. I mean, she's looking at 12 to 18 months in prison, assuming the judge gives prison. If there's aggravation, she's agreed to aggravation, up to 3 years. And if she participated in that, even after the fact, I'd be surprised if any judge did not send her to prison. If she thinks she's getting probation, wow, that'll be very, very interesting to see. Let's see here. Ask a question from Christine Veradris. I hope I pronounced that correctly. Scott, did Lifetime have to get family permission to make this upcoming movie? Will they have to pay the family? Can someone make a movie about you without your permission? Do they have to get permission? No. Can someone make a movie about you without your permission? Yes. It's called it basic. People write books about people all the time, an unauthorized biography. So yeah, they don't need the permission in any way whatsoever. Any way to stop Lifetime from putting the movie that they're doing next year? Why do we glorify killers by doing this? It's interesting. No, I mean, the only thing that could stop Lifetime, I think, would be, for lack of a better term, kind of public shaming. But think about it. This is what people want to see. There are channels out there that do almost nothing but exclusively crime talk type of channels, whether it's YouTube, whether it's TV. This is what people want to see. It's, for whatever reason, it is super fascinating for people to see what goes on, whether it's the psychology of the person who is accused of the crime, what led up to it. It's something that people, I think, are intrigued by, and I think it's something that they don't understand. I can tell you, as a criminal defense lawyer of some almost 25 years now, that there are things, just when you think you've seen it all, just when you think no one can tell you anything that's going to shock or surprise you, it happens. And I do this on a daily basis. So I think for kind of the everyday public that goes to work, lives their lives, they hear about these kinds of cases where people kill their spouse, the children are harmed in some way. That people, I think, more want to see simply, it just, they want to see the psychology behind it. They want to see how this happened. Why did it happen? Because it's so beyond most people's realm of belief that they think that anybody could be so Hepstein or so heinous towards another person. And like I said, like somebody who's seen, in my opinion, pure evil over the years, pure evil does exist. It does. And what does pure evil look like? I don't know. I've seen pure evil, that goes to work and looks like, Mr. Preppy guy from the East Coast. I've seen pure evil that, for a lack of a better term, looked like he was, out of deliverance. Or, I mean, it just, what does it look like? It's all around us. People don't know what other people are capable of. And when people want something bad enough or think they can get away with it, they will do it. It's I don't know. But I think people are fascinated by it. And I hopefully think that the reason why people watch our channel here is because we try to give some perspective on some of these cases, hopefully more from the legal aspect, explaining things as to how they're taking place and what you can kind of anticipate or explain something that went on in the way it did. But it also, I think people have a desire and need to see what makes these people tick that would go out and do terrible, heinous things to other people or to their family members or to strangers, even, for goodness sakes. What causes somebody to get up and say one day, I think I'm going to go do something bad to that person? I don't know. Are they just not wired right? Are they having a bad day? Did they have a bad cup of coffee in the morning and it just started things off that way? Or are they just not wired correctly? I think if we knew the answer to that question, we'd solve lots of problems. But I also think if most people knew how much crime took place in their communities, they would literally lock the door, wouldn't come out at night, and probably be sitting there with a handgun and or some sort of firearm and shoot at any noise that comes their way. It is a dangerous, dangerous world out there, ladies and gentlemen. And I'm coming from the perspective of a criminal defense attorney. You guys have no idea how much crime exists out there. We talk about kind of the dumb criminal of the week, okay, but there's bad stuff that that goes on out there. That's serious stuff that affects people's lives, where there's actually truly innocent victims whose lives have been completely changed because of complete random acts of violence that you just can't understand. And it's a scary world out there. Trisha Cowley, the DA should never have given Kenny that sweet, unbelievable deal. I cannot agree with you more. But guess what? How are they going to show otherwise that they believe that Miss Barrett is gone? They have no other witnesses. They have no body. So they had to cut that deal with her, not from a position of strength or that they thought that she was, the least culpable. They did it because they had to. They had no other choice. Otherwise, this case, I don't believe, could go forward. It'd be nearly impossible to do that. A gentle soul. My electric bill was evil this month. I understand. That's funny. The Chris Watts movie won't show anyone that's been on YouTube haven't seen already. I completely agree, unless there's some sort of Chris Watts exclusive interview, which I find unlikely. Shouldn't have given that interview. Yes. Let's see here. Let's see what this comment was. I once had a lawyer. I lost it. I lost it. Sorry. Scott, if he went to trial, referring to Chris Watts, do you see something different outcome or something worse happening? If he had gone to trial, I believe he would have been convicted. I don't think he would have received a death penalty. So I think it would have been basically the same result as it is right now. A gentle soul wants to know, Scott, what's the worst case you've handled? Wow. Well, in the sense of the worst case I've handled, I think from a gory aspect, it was a cold case. It was a multiple homicide. There were 3 deceased bodies. One person who had his throat cut lived and survived to tell about it. And so from a gruesome aspect, the pictures of it, that was probably the worst. From the pure evil aspect of it, once was a case where someone was accused of doing terrible things to a friend. This person knew that the person was the relationship had ended, and that he basically went to the house and did terrible things to that victim in that particular case. And then afterwards, the person was he videotaped what he had done. The video was found. He was prosecuted on those particular cases, and then basically the conspiracy to have the victim eliminated was the case where I would say is probably one of the worst cases ever, where it was literally just pure evil. So let's see here. Question: could Chris Watts ever have a retrial? Unlikely. No, never. So slim a chance, it'd be useless. We've talked about this. He would have to file. He doesn't have a time limit on it, but you only get one bite at the apple. He would have to file what they call a post-conviction relief pursuant to Rule 35C, stating that his plea of guilty was obtained unconstitutionally. Well, that's going to be unlikely because, one, the colloquy between Chris Watts and the judge was on the record in open court explaining this is what he wanted to do. He's doing it freely, voluntarily. No one's putting pressure on him to do so. He was aware of the elements to which he pled guilty to and the consequences. Game over. The only thing he could possibly do is to say that his attorneys didn't represent the case. But if you listen to the Chris Watts interviews, he says that his attorneys were ready and willing and able to go defend this case, and he's the one that said, nope, I'm taking the guilty plea. So Chris Watts is never going to get a new trial. Chris Watts is never getting out of prison alive. Not going to happen. Let's see here. Talk about the SoCal officer whose police dog died in the car while they were away. I am not familiar with that, but, we talk about people not leaving their children in the cars. We talk about people not leaving dogs in the cars because it gets too hot. I am not familiar with the Southern California officer whose police dog died in the car while they were away. Most of the time, I've never seen a police dog vehicle, they leave it running. I've seen him running, just constantly whenever the dog is in there. Let's see. Haley Hall, divorce rate is high. Lots of married guys asking, how did this happen and could it happen to me? Explain the popularity. I'm not sure I understand that question. Let's see here. Ooh, Mr. Let's see here. Let's see. The guy who killed a man over a parking spot in Florida and tried to use stand your ground defense found guilty. Florida finally did something right. Now, I'm not going to say that I know exactly what was, Florida's stand your ground. Bottom line is, you always have a right to defend yourself. Okay, self-defense is an affirmative defense. If somebody is attacking you, and you have a right to defend yourself. I mean, it's kind of a fundamental right. You have a right to defend yourself, but you have to use it reasonably. Okay, if someone is arguing with you over a parking spot, even if he says, "I'm going to kick your you-know-what," it doesn't give you the right to pull out a gun and shoot somebody, because what you still have to remember is that your response still has to be reasonable. What would a reasonable person do? If someone threatens you with a gun, then you can use a gun. If someone threatens you with your fist, you probably can't use a gun. It has to be reasonable. So that is probably the right decision in that particular case, just because you're having a bad day. And like I said, I have said this before, ladies and gentlemen. I tell this to clients all the time. I love guns. Nobody would defend your right to have a firearm under the Second Amendment more than I would, okay? But guns complicate everything, okay? And if you have a concealed carry permit, be smart about it. It doesn't give you a license to put it on your dashboard and show somebody that you have a gun to somebody cut you off. Guess what? You just committed a menacing offense right there, because you put somebody in fear of serious bodily injury or harm in that particular way. It doesn't mean that you get to shoot somebody over a parking spot. If you have a gun for self-defense purposes, and there are many, many people that legitimately carry concealed weapons permits, okay? I have a concealed carry. Some days I carry, some days I don't. Most of the time I don't, because I'm in and out of courthouses all day with metal detectors, and I don't want to leave anything in my car, okay? But the reality of it is, if you have a gun and you carry it, you better be able to explain that you had no other alternative than using that firearm at that particular time, that you had no other way to respond. You had no other time available to you to do something else. Okay? So I tell people, if you're going to use a gun, it complicates everything. Make sure you can explain to a jury of 12 people you had no other option. That's the only thing that most people don't think about. And it's usually because they got a hothead. Let's see. Louise P., do you think Prince Andrew knew that Epstein was up to, Scott? Let's face it. All of these people that were with Epstein either before or after he was convicted, do you think nobody knew what was going on? Do you think nobody said, "Hey, Jeffrey, tell me about that case that you got going on. How did that work out for you? Hey, you still having to register as a sex offender?" Yeah. Why would you put yourself in that spot? Why would you put yourself hanging out with that particular individual, knowing what he had done in that particular situation? Let's see here. Why does Nicole Kessinger not go to jail? I strongly think she's the only reason why Chris Watts did his horrible things he did. We've talked about this, okay? Let's face it, Chris Watts meets Nicole Kessinger. Nicole Kessinger rocks Chris Watts' world. He thinks, man, this is great. I want to go be with her. This whole being a father, being broke, being a husband, living beyond my means, can't afford anything. Boy, it'd be nice if I had a fresh start. Yes, he should have just gone and got a divorce. Okay? But for whatever reason, he thought that this is what he wanted to do, had to do. Who knows exactly what reason he did it. But the reality of it is, and I've said this before, I don't believe, short of Watts coming forward or some sort of text message coming forward saying from Kessinger to Chris Watts, you need to get rid of your family. You need to do something like this. Or, hey, I'm going to do this to my family. Come over and help me. Short of that, she's not going to be charged. The district attorney has made their charging decisions in this case. And short of some direct evidence, a confession by Kessinger or a statement by Watts, not going to happen. It's over in that regard. So, no. Let me go back here. Apparently there was a super chat. Will the Watts DA ever be able to speak out? That was a super chat from Heather Harris. Sorry, I missed that. Super chats are supposed to be able to be right there so that I could see it. The DA has spoken. I don't believe that there's going to be a whole lot more he can say. Not all, but a good chunk of the discovery has been released in this particular case. If there was an ongoing investigation, the district attorney would say there's an ongoing investigation and I can't speak about it. He said his piece. I think he's going to, out of respect for the victims in the case, I believe that they will not say anything further about the case. Let's see here. Question. Wondering if Chris Watts had gone to trial and faced a death penalty, were the investigators going to be more motivated to investigate deeper and find evidence that leads to convict an accomplice? Yeah, no. It was everybody knew it was going to be probably a death penalty case from the beginning, just given the facts. Do I think that it motivated that would motivate the police to dig deeper? No. And if there was some evidence there in the beginning, they would have charged it had the evidence been there. There's nothing. Yes, did Miss Kessinger do things that certainly make her look like a not great person? Yes, but think about all the things we've all done in our life that we would probably do differently in hindsight in 2020. People in that situation, they panic. They don't know what the hell is going on. She thinks she's dating this guy. Yeah, he's getting divorced. Hey, she's having an affair with the guy. This stuff happens, right? But I don't think she signed up for, being married to the guy that's willing to kill his wife and 2 children and an unborn child. That is simply, I don't think anybody thought or anticipated that. And frankly, I don't think that guy was worth risking everything like that for him. I mean, the guy could barely, keep up with the bills, so to speak. I get it, people. You want somebody else to blame. You think she may have been responsible, but you have to have real evidence, not speculation. They wouldn't have enough evidence that a judge would sign a warrant at this point for her. Just because we think, if somebody says, oh, she's a horrible person, she had an affair with a married man, guess what? That's not a crime. Okay. Some states it's still in the book, adultery, but it's never prosecuted. It simply isn't there unless some other true evidence comes up, and I just don't think that it's going to. So let's see. Darcy, have you ever received a death threat? Yes. I've had clients that have brought guns to the office that were upset with the offer, and I told them it's time to go and quickly removed from the case. Let's see. Being there. We banned guns in Australia after the Port Arthur massacre. The government had a buyback scheme. Haven't had a gun massacre since. Well, but I don't know what your constitution is there, but here we have a fundamental right to possess firearms. And I get it. Some people don't like guns. Yes, people do stupid things with guns, but our fundamental criminal justice system is based upon. You punish the person that does the crime. If somebody commits a crime and uses a gun, by God, punish them. And they use a gun, punish them harsher because they interjected this more dangerous situation where somebody could have been killed. But you don't go to the next door neighbor and say, we're going to punish you for what your neighbor did, so we're going to take away your guns. It's going to make me feel safer. It just doesn't matter, okay? If I am a responsible gun owner and have done nothing wrong in all my years of ownership and try to be a safe individual, then I should not have my rights taken away. If I do something stupid where I, discharge a firearm, it goes through the wall and, hit somebody, then by God, hold me responsible. I'll be the first one there to do it. But you can't punish somebody else and take away their individual rights of what somebody else did. Could you imagine one day we have court and we're going to punish the entire city and take away all their rights that they have to punish this one particular person? We just don't do that in our system. And, I simply do not understand. I love the Constitution. The Bill of Rights was the greatest thing ever done. The First Amendment. People aren't, it's crazy. You hear people that are willing to give up their First Amendment rights. Can you imagine that? Can you imagine people saying, I don't want freedom of press, freedom of speech, freedom of religion, right to assemble, okay? And people are like, give up. I don't need that right, so just give it up. I don't need that. That absolutely blows my mind that anybody would give up their individual rights. For anybody. I mean, how do you know when you're going to need them? Let's see. I have protection at home, but not running around town with it. And that's choice. If you follow the law, then you can do that. Let's see here. I'm sorry about that. Let's see here. Let's see here. I'm sorry. I hit the little screen and it jumped around here. Let's see here. Stephanie, what about all the undeniable coincidence and clear lies and whatnot? Do you think LA investigated everyone fully or just brushed it off when CW confessed? I think they investigated it fully. Hey, here's the other thing. People lie to the police all the time, okay? You don't think it's true? How many people have been pulled over by a police officer for speeding? Show a raise of hands. Come on, raise your hand. Yeah, you did. And what did the officer say? Do you know how fast you were going? And the person says, ooh, no, I didn't. No. Guess what? You just lied to the police officer, okay? People lie when they get scared. I don't care if you're a kid who took the cookie from the cookie jar or an adult who got pulled over for speeding. People lie to the police all the time. If that were prosecuted, the justice system would be shut down forever. Okay? Let's see here. I go live when I get on the top. Okay, we'll talk about that. Huge roll. We got that. Addie's mom. Can't seem to comprehend the laws based on facts. Yes, facts. Do you think that Watts will survive in prison? As far as I understand, Mr. Watts is now in solitary confinement, or has limited restriction. He's not in general population, as far as I know. But I think that once he gets there, life is going to be very, very difficult for him. We've talked about before kind of that hierarchy in prison. If you've committed murder, you're on a much higher ladder step, so to speak. There's certain crimes that are not, if you kill somebody, shoot somebody. I mean, prison is based on a pretty, who's the more powerful, who's the strongest type of thing. You start getting in where people have been convicted of sexual offenses. They're much lower on there. And obviously, if you harm children, and I think that's simply based upon the fact that so many people that have been in prison have been harmed in some way, whether physically, emotionally, or sexually, that they just have no respect for that, and they can control that because, frankly, it's simply not done there. Isn't Scott Peterson getting a new trial? Not that I'm aware of, but Scott Peterson also went to trial, but I thought everything had been exhausted, so I don't think so. Oh, no, super chat. Let's see here. Did I miss it? Did I go? Oh, here it is. Does Ellie have to tell you if you're under investigation? So does law enforcement have to tell you if you're under investigation? Not really. No. They don't at all unless you are being interviewed and you're in custody. They can come to your office, have a consensual conversation with you. You agree to sit down with them and say, hey, we're investigating some things. We'd like to talk to you about this. And you can say, ooh, I don't think I want to. Because remember, you don't have to speak with the police. And they normally won't tell you you're under investigation until and if they've already interviewed people and they want to talk with you to get your, quote, side of the story. But wouldn't advise anybody on doing that because nothing's good going to come from that. They usually try to interview the target of the investigation last. And that usually means that it's just about coming to an end. Let's take a look here at something really fast. And sorry about this. Just want to see here. All right, we've been almost an hour, haven't we? Wow. Okay. Okay, let's go back here. See, there are a couple more questions here. Let's see here. Thank you, Karen Welch. True Helper. Thank you. Betty Spaghetti, did NK take a polygraph? Not to my knowledge. London Girl, appreciate you tuning in. I really do appreciate that. It never ceases to amaze me how many people comment or direct messages we've received from people from around the world, and it's always nice to hear kind words where people say that we've taught them something or explained them something about the American judicial system, because there's so many things that people simply just don't understand. And not that I know everything or have all the answers, but I usually try to, obviously I want to always get what I say correct. Most of the time, I think we do a pretty good job of trying to get it correct as well. But, most people don't understand the American judicial system. I've seen legislators that have no idea what they're doing, and they are the ones writing the laws that are going into effect on the criminal justice system. And that's always my pet peeve as a defense attorney. People will say somebody got off on a technicality. No, it's not a technicality. Okay, it's the law, and it just irks me to no end when they say technicality. Since when is the law, the Constitution, the Colorado Constitution, the statute, when is that a technicality? All right, let me see. Try not to skip it here. Let's see here. Looking one more time. Oh, there it was. Laura, what is propensity evidence and how is it used? Well, that's what we were talking about is the 404B evidence. The defendant has the right to be tried on the charges that he has in this particular case. You can't bring up everything they've ever done in their past life to say, look, he's a bad person. Propensity evidence is really saying he's committed crime in the past, therefore he's a bad person, and he has the propensity to do it again based upon that information. Prosecutors like it. They say, look, we're not bringing it in because he's a bad person. We're bringing it in to show that this is his modus operandi. This is his absence of mistake. There's various things that it can be brought in under what they call Rules of Evidence 404B, evidence of other wrongs, crimes, or misconduct. But the defendant has that right. Oftentimes the judge brings it in if it meets the legal standard to do so. I personally think from a defense perspective, it complicates cases for the prosecution, and sometimes like, hey, bring it on. And then, but unfortunately, then you have a lot of these little mini trials. And from a prosecutor, if you think your defendant that you're prosecuting has done something, then just present the evidence on that particular case and get him. I think 404B evidence on the part of the prosecutor shows that their case is weak. So hopefully that answered your question, Laura, and appreciate the super chat. Let's see here. Watching the video. Let's see. They're watching your videos now, April P. I'm not sure whom you're referring to. What is a subpoena and what does it... Oh, I lost it. I touch my screen because it stops and then it speeds up and I lose some of these questions here. Okay, what is a subpoena? Okay. There's two types of a subpoena. If you receive a subpoena to appear in court, so let's say as a witness, that's your subpoena. You have to show up. If you do what they call a subpoena ducis tecum, that is basically ordering somebody to show up to court and bring particular documents that they have, okay? You can't issue a subpoena unless there's actually a case ongoing, and you also have to give notice, whether it's a civil or a criminal matter, of the opposing party that you are seeking those documents. So let's say, for example, I have a child abuse case, and the child states that he would go to school every day with bruises and welts and what have you. Well, I would then want those school records of that child to see if there's any notation of that to, is corroborating that or not corroborating that. So I can issue a subpoena to the school district. I have a date that they have to return it by. And in a criminal case, here you have to produce those items in court. You don't get them just sent to your office. In civil cases, sometimes you can, but really both sides gets a copy to them. They're usually deliverable in court. The person has to show up who's producing them, and that also gives them an opportunity to file what they call a motion to quash. If they say, hey, these records that you are seeking are privileged, we cannot give them to you. Let's say we have school records. Using the school records example, if I have school records and they're going to be produced, but they say we also have some nurse medical records, and we believe that those are privileged under the law, and you can't have them. Usually then the court would take them, and if there wasn't an exception, he'd say, well, I'm going to quash it as to the medical records, but it's kind of at issue. So you have to see if the victim would give a release, or if there's an exception, would the court look at them and say, I'll look at these. If they're relevant, I'll give them to you, but I'm going to put them under protective order so you can't give them to anybody else while you look at them. It doesn't necessarily mean they're going to come into evidence. So that's what a subpoena is. Basically, a subpoena to produce. There has to be something where it's started, where you could actually, a case is started where you can have an action. You just can't walk up and say, boy, I'd like to get the records of somebody's phone records and send it to the phone company, and you would get those. That it doesn't work that way. Grand juries can send out subpoenas. There's administrative subpoenas for law enforcement agencies, for example, to get documents during a course of investigation as well. So hopefully that answers your question. All right. Okay. We also had Black Rose 1-1 who sent a super chat. Thank you very much. Thank you for the nice words. Let me run back up here. Carol Wilson, super chat. Why is attempted murder not punished the same as murder? Attempted obstruction of justice is the same as actual obstruction of justice. Good question. Let's think about it. If you are charged with murder, obviously it means that somebody believes in the state that you have been successful in completing the crime. But yet attempted murder means you failed. Maybe you're not a good criminal. Somebody survived, using the murder example. Then the punishment is not as great. So say, for example, I'll use Colorado because that's what I'm absolutely most familiar with. So murder, you're looking at life without parole. Attempted murder, you're looking at 16 to 48. Why should you get off less time for not being a good criminal? You still had the same intent. Well, you know what the simple answer is? Ask the legislature. They're the one that writes the laws. They're the ones that set the penalties for all criminal conduct. But I guess it somewhat makes sense is that you got lucky. You didn't harm anybody else. You didn't steal something. You didn't break into the house. You attempted to do it and you stopped. Maybe it was your good conscience. Maybe you were too stupid enough to bring a big enough sledgehammer to knock the door in. Who knows? It's something along those lines. But yes, you get a break for not being successful in criminal law. It really doesn't make much sense because normally you still had the same intent at the time that you were attempting to do it. You just didn't succeed. All right, HL, thank you for the nice words. Dead Reckoning, I appreciate that. Yes, the Magic 8 Ball, that's how we make all our great decisions. Appreciate everybody in our little crime talk community. This channel could not exist without you all. And every day, I literally see our subscribers go up, and I appreciate that. It is not taken for granted. I assure you of that. Frankly, I'm rather humbled by the fact that people would want to listen to something that I had to say, and hopefully it means by the fact that we're increasing in our subscribers that we're saying something of some value and some worth. So we really do really appreciate that. It's frankly quite humbling, and I take it every day. We try to put out good content. We hope to make it better. If you look at some of our first videos we put out, I'm actually somewhat embarrassed by those, but it was a learning process. And every day I hope that we are getting better to put out a better product for you. I just wish sometimes there were more hours in the days where we could get it all done. Or I win the Powerball and I could simply just do this and wouldn't have to, lack of a better term, keep my day job, so to speak. But I still do love my day job. It's exciting. It's fun. It's intellectually challenging. There are frustrations, I assure you, whether it be judges, district attorneys, and clients. Some days it is it has its ups and downs. Some days you want to go work at Starbucks and get that instant gratification that you've made a good cup of coffee, and not hear about 2 years later where somebody says you didn't do something you should have done or what have you. So let's see here. I'm sorry, I missed a question here. Let's see. Please answer Ginger, Scott. Let's see. Where's Ginger? Ginger. Let me see. She's asked twice and she needs an answer. Let me see. Ginger, I have an ex that was displaying stalking behavior and following me and waiting for me to come home. Should I get a restraining order? Will it help? And is he notified of the restraining order? Yes. If someone is stalking you, all right, you need to report that to the police. Don't wait until it gets to the point where some harm has come to you. You need to document that immediately. You go to the police department, you say, this is what's going on. They'll decide, hey, wow, this is really creepy, particularly stalking. We're going to investigate this. Okay. Most jurisdictions, felony, following somebody around, engage in weird behavior like that, it's a felony. So go report it. And you can say, hey, you know what? I don't want to cause any trouble just yet, but I at least want this documented. So by God, if something happens to me, I know where to look. Hopefully it never gets that far. If a criminal case is filed, there will be a protection order put in place where that individual cannot have contact with you during the pendency of that case. But you can also go and get a civil protection order where you go to court and say, hey, this person is engaging in this conduct. I'm in fear for my safety. I believe it's a credible threat, etc. The court will then grant you a temporary protection order. The court will then tell you you have to have this other party served. Usually do it through the sheriff. They will have a return date, usually within 14 days in most jurisdictions, where it says you have to have a hearing. And you show up and then you state under oath what you believe to be this conduct, why it is putting you in fear, and that it will continue but for the fact that there's a protection order in place. If the party that you serve does not show up, the protection order goes into place. If you, the person trying to seek the protection order, doesn't show up and the other person shows up, the case goes away. If you want the protection order, the other person says, no, I don't want a protection order. I didn't do anything wrong. There's a hearing, and the judge will decide whether there's been sufficient evidence for a protection order to remain in place and become permanent, or to say this just doesn't rise to the level. Most judges will grant a protection order because they don't want to be that judge that lets somebody not get a protection order and then ultimately something bad happens to them. Some judges will call it for what it is. If it's harassing, if it's just done to harass the person which whom they're seeking it for. But for the most part, I think people seek those for legitimate purposes. There's always going to be those few that use it as a tool. But understand, once you get a protection order, yes, that person cannot have contact with you, but you can't then contact them and say, well, I want to talk with you while it's convenient for me, but I want to be able to change my mind at any given moment and get that other person arrested. Because if you contact the police or you're found with that particular person, that other person goes to jail. So when it means a permanent protection order, it means that you permanently never, ever, ever want to talk to this person again. So hopefully that answers your question. Your content is unique. Thank you. Let's see what else I got here. Please give a thumbs up. Black Rose. Please make sweatshirts cheaper. I want one. Okay, well, those prices aren't really set by me. They're set by Teespring, but I think they're pretty reasonable, and I think they're I think it's totally reasonable, and I don't. It's not like I'm going to quit my day job because I sell a couple of sweatshirts, but I have one. I like it. I think they're great. Dead Reckoning, thanks, Scott. We subscribers appreciate you. I appreciate that. Like I said, I wish I made sure to get that. Scott, have you ever had a client you knew was guilty? Yes. Let's see here. But let's see. He confessed. He pleaded guilty. Why would Chris Watts get an appeal? There wouldn't be any appeal. He would have to withdraw a guilty plea, which isn't going to happen. Share a sub if you haven't already. Thank you. Appreciate that. Tell a friend. Appreciate it. Nina, yes, please make the sweatshirts cheaper. Well, like I said, I don't really set those prices. Those are set by Teespring. But, you can always get a T-shirt. So you can always do that if those aren't there. So let's see here. I think that's just about it for the day. I appreciate everybody for watching. If you like the channel, please subscribe. If you like our video content, you like when we go live, please like that video. And go back and watch some of our older videos that we've done. I think there's some good content there. I think that we, truly try to be relevant and do everything we can to help explain the legal system. Have a quick super chat here. Amanda Hart that I saw just, would Watts have a chance if he sought a lawyer during his interrogation remained quiet since his family's bodies had not been found. Yes, I cannot imagine why he went in at all. He should never have talked to the police. He should have gone straight to an attorney, and I think things would have been a lot different. But most people don't understand their rights, and I'm not saying that would have gone away, but if you're being accused of a crime, exercise your rights, okay? You have a Fifth Amendment right to remain silent. People want to get rid of certain Bill of Rights. Well, geez, why don't we just get rid of the Fifth where we have to force people to talk? Yeah, we don't do that. Why? Because the evil king did that, and that's why we started this new country, and that's why we did it, because everything that the king did are all in those Bill of Rights. That's why we don't want to give those up, because it was based upon they knew what tyrants do. They knew what tyrants would do to people that were charged with a crime or that spoke up against the king. That's why everything in the Bill of Rights is there for a reason. Okay, whether it's free speech, assembly, press, firearms. You can't have troops come to your home. Right to be secure in your place under the Fourth Amendment. Right to due process under the Fifth Amendment. Right to remain silent. A right to counsel. Right to a trial. Those are all things the king never wanted anybody to have or do, because he wanted to be able to throw his enemies in prison. That's why we have those rights. That's why they're so special. Don't ever, ever give up your rights. And yes, if Chris Watts had called me, I assure you, I would have told him to shut his mouth. If he had called any criminal defense attorney, things, I think, would have been a hell of a lot different. I assure you of that. Anyway, thank you for watching. Have a great day. Please like the video. Please sub. Go back and watch some of our other videos that we've done. I think you'll find them informative. I think that you'll like them as well. And we'll talk to you soon. We'll have new content coming out this week, and we'll try to go live again as well. Have a great day.